Hello everybody, my name's Ryan Day. I'm partner and head of technology at Moore Smith. Today we're talking all matters legal around growing technology businesses, from everything from governance, IP, international expansion through to exit. As a little fun fact, Moore Smith were one of the first accountancy firms to have a legal offering outside of the Big Four, so it's something that we're uniquely proud of. And here I'm with Andrew Bloom, partner that leads that team.
So what we do for SaaS businesses is we help make sure their legal framework supports their growth, whether that's scaling in the UK, expanding internationally, preparing for an exit, helping with fundraising and beyond. Our real USP is joining up legal, tax and accountancy services under one roof. This gives clients real efficiencies and makes sure all the various elements are joined up.
And so governance is something that CFOs lean into as companies scale. What should they be focusing on from your opinion?
Well, shareholders' agreements and the articles of the company set the rules for how the business is run. Board structure, information rights, approval thresholds, and who can block or approve what. As a SaaS business grows, these documents often fall behind reality while people are focusing on growing the business. But we help clients refresh those documents so that the company can move forward quickly, take strategic decisions effectively, and still protect minority investors. Some of the key things that we look at and we talk to clients to make sure things are properly aligned are whether reserved matters and veto rights slow down or help the decision-making process, if information rights match the way the business now reports its performance, and whether board composition still reflects how the company's actually run. Our key aim is to reduce friction before fundraising, expansion or exits.
And so I've seen examples in the past whereby clients, founders have looked to change the water flow of, funds on an exit. What you're saying is it's important to get that in place before any deal's on the table, because it's too late basically to change once the offers are tabled.
Yeah, it's much easier to agree things when people, optimistic about the business in the future. You don't quite know what values you might get, but when the money's on the table and people want to start renegotiating, that's not the best time to be doing it, because you're better off focused on selling the business and impressing any investors and buyers.
Yeah, and obviously one of the key things for any growing SaaS business is fundraising. Whether that's from an angel investor, seed, Series A, et cetera. So how do we support those businesses on that journey?
Well, we help clients make the fundraisings happen cleaner and faster in three ways. Firstly, for early stage companies, for SEIS and EIS investments, we coordinate with our tax team for the advance assurances where that's needed. We help make sure the company's activities and share terms are compliant with those rules, and align the cap table so that future rounds of funding and future investors aren't blocked by the early investors. Secondly, documents and due diligence. We help update the shareholders agreement and articles, help with the data room and disclosure pack, and make sure investors' rights, so information, preemption rights, consents, are all calibrated for future rounds. And thirdly, as a multidisciplinary firm, here's where I often think we really do add the most value. Again, it's liaising closely with colleagues in our tax, accountancy and corporate finance teams so that the whole process is joined up. And we don't just play lip service to this. Yesterday, I was speaking with a client regarding a transaction we're working on, and he volunteered to me how wonderful it was, those three different elements of our service all joined up, and it made it far less stressful and a much smoother process for him. So that was really great to hear. But then we also help clients with Series A and beyond, but the principles are still the same. It's about commercial awareness, minimal friction, and future-proofing, in particular regarding preemption rights and consents, and avoiding veto sprawl. You don't want people who are no longer connected in the business having too much rights to block its growth for reasons of conservatism or other things. But the business needs to move forward.
And how would you deal with a scenario like that if there was a key employee that had exited the business, and they don't want to negotiate? What actions, levers can you pull in that situation?
Well, it's all about getting the documents right from an early stage. We've seen businesses where the documents weren't quite right to start with. Either there was lack of certainty about who owns the shares, whether the share cap table reflected what was agreed, whether people had rights or were promised shares or options in the future, which they hadn't yet received. And often you can resolve those. It can be obviously much more expensive and it's a distraction from the deal. In extreme cases, I've seen one or two deals collapse because the buyer or investor said, well, there's easier businesses that I can invest in who've got these things right.
Yeah.
And if an investor's got a choice, you'd rather kind of get on a happy ship than one that isn't a happy ship.
And what would you say is where you add the most value to this process?
I think to be honest, it's experience and joining it up. And also if you're about to make a change at the last minute, that can often cause a tax issue. It's much easier if you deal with those at an early stage. And clients will never find us saying, oh, well, you could do this, but you need to go and check with your tax advisors or something like that. We're all under one roof, so we'll come up with the answers and the solutions together.
And we haven't yet touched on IP, but one of the fascinating things that always comes up certainly from my own clients is, founders might often come out of university or, an idea will be formed in the garage or over the dining room table. They don't necessarily write down who's, developed which parts of the IP. How do we resolve disputes around that sort of thing?
That's a fundamental thing to get right. And as you said, when people are just starting up a business, optimistically, they're focused on the business idea, they're focused on the tech and how they're going to build it. And often they'll do things on a handshake, if that. And so we have seen cases where investors have come along. There hasn't been certainty over the chain of IP, who wrote the code, whether it was properly assigned to the company, whether they did it for this company or another company, whether it was licensed or partly used someone else's code. And all of these will be very big concerns for investors and acquirers down the line. And in some cases, it will either significantly reduce the valuation or investors and acquirers will walk away. So, for example, just last week, we were contacted by a client. The business is now worth several £1 million. The guy who basically runs most of the business wasn't able to get things properly documented from the start, and now it's much more difficult to do it to do it after the event. So it is something that we need to try and deal with at an early stage. The solutions that we found are often far more expensive than they otherwise would be. You end up either having to paying off somebody to agree to give up what they perceive to be their rights or to settle a claim. And it would have been much easier if it had been properly documented from the start. And
this presumably is where the joined up approach with tax works, because no doubt there's a tax leakage on those scenarios.
Very much so. But also, I'd also add that it isn't always grim. Very few businesses that start up are perfect. There's often part of what we do as advisors is help clients solve problems. And if there is a problem and it isn't perfect from day one, there's almost always a solution that we can find. But it needs to be done so that if there is going to be a tax hit, you know what the tax hit's going to be before you go down that path, and thinking creatively in terms of how to resolve differences between parties with differing views.
And quite a lot of our tech businesses will naturally look outside of the UK as they grow. How have we supported clients on that journey, whether they've invested into mainland Europe or maybe into America? What sort of things are causing you sleepless nights there?
I'm pleased to say no sleepless nights at all, Brian. I know maybe that wasn't the right answer, but no sleepless nights because we've actually got such a great connections with our international network, be it lawyers, accountants, business advisors. There's a technology business at the moment that we're helping possibly move to the US because they found some US investment there, and lining it up with advisors who we know through our network in the US in terms of corporate finance, accounting, and also on the legal side.
And one thing we haven't touched on that journey is, I suppose, employment legal issues. Is that something that we can support companies on that journey with?
We've got an employment law team, employment taxes, global mobility. So to the extent that we need to help businesses help their people move cross borders, whether it's immigration concerns, tax concerns, dealing with the HR issues, all of that we can help with, as well as helping with employee incentives and stock options, and an employee with a stock option in the US, translating that to the UK isn't always a simple process, but there's ways of doing it to make sure that people's motivations are aligned, employees remain engaged and incentivized, and the company knows what it's costing them.
Sure. And I suppose then exit is obviously naturally what a lot of founders are looking towards, whether that's IPO or a trade sale. I suppose from your perspective, what things matter most at that stage? What should they be planning for?
Well, it's almost like trying to think like a buyer early. If I was a buyer, what would I be looking for in this business? So it's cleaning up the cap table, making sure the chain
What do you mean by that? Sorry, just to ask.
So the cap table, capitalization table, like who owns what shares, how many shares of whatever class, whether people have been promised shares by way of actual stock options or phantom options or different types of equity incentives, or maybe they were just promised that, if you carry on being a good citizen, we'll look after you when the deal happens. And if those people may not have legally enforceable rights, if it was just a verbal promise, a buyer who comes in isn't going to want a whole bunch of key employees to be disgruntled when the deal happens because they felt let down. So it's important to make sure that everyone's treated fairly, because that's what's always going to make a more successful business and in the future once the buyer or investors have come in.
And so I guess, from a CFO, looking to do one of these deals or an exit, what should I be considering first?
Well, so as well as making sure there's clarity as to who owns what shares and options and that sort of stuff, the chain of title of IP is very important to get verified. Checking for customer contracts, whether they're assignable if they're to die, so they could be easily transferred to a buyer or investor within the group. Checking that there are no change of control provisions that would allow clients or customers to terminate if there was a change of control in the business that we're about to invest in. So having a ready data room, because that way if a buyer comes in or an investor and they want to move quickly, if you've got all those documents together in a data room, you can manage it better and more effectively, and it's far more impressive when the buyer wants to do their due diligence.
Well, and also coming back to the point you said earlier, if you've only got one data room to work with rather than one for your tax advisors, your legal advisors, that there's cost and time benefits there as well, aren't there?
Absolutely. It's kind of like reduces the longer a deal happens, the greater risk something could happen that would make a buyer or investor walk away or look at something else, and you want to make it as smooth and impressive as possible. Once a deal happens, once they've gone past the initial due diligence and we're in the deal phase, we help manage the SPA, the share purchase agreement, disclosure letter, warranty and indemnity insurance. Also help with rollover equity, where people are like transferring their shares from a current UK business into maybe a US one, and also earn-outs and post-closing covenants in terms of what people are supposed to do after the transaction.
Well, thank you for that summary today, Andrew. That was very informative, and there's lots of good advice in there. And thank you for listening, everybody. That was Andrew Bloom, Head of Legal at Moore Smith. If you've got any tax and legal matters, please reach out to Andrew.
Thank you.